When I first came here in 2004 with Mr. Haston, I heard these mumblings and rumblings about Touro. It was, just a public interest law school. It wasn't a serious law school. They didn't have really serious law there. Everybody knew that all of their graduates worked for legal aid and the public defenders. Folks, it's not so. It's not so. After 30 years, Touro Law School is a wonderfully diverse and broad-based law school, teaching all kinds of law and graduating students with all kinds of interests. For instance, alumni of Touro Law School work in every major Long Island law firm. Sir Tillman Balin, Myers Swazi, Cullen Dykeman, Farrell Fritz, Jaspin Schlesinger, Louis Joes, Rivkin Radler, Ruskin Moscow. I mean, the list goes on. And Touro Law alumni work at virtually every major Manhattan firm. Fried Frank, Dickstein Shapiro, Reed Smith, Wendell's Marks, Dorsey Whitney, Kay Scholler, Skadden Arps, Wilkie Farr, Milbank Tweed, Latham Watkins, Milberg Weiss. I mean, the list goes on there too. So please do not believe this nonsense about Touro Law and its limited blinders approach to the law. Now, that being said, our faculty and our curriculum do take a serious approach to justice and to public interest. Why? For two reasons. One, it helps teach our students lawyering skills to our law students. And two, it teaches compassion for the underserved. Very simply stated, our students graduate with an excellent skills education, but also with an understanding of the compassion that they must bring to their task. So tonight, as we celebrate and as we thank and as we honor our 18 builders, I want to talk honestly and I want to talk frankly about what it is that they have built. What is this thing called Touro Law School? This is Carol. She was a client of Jack Evans in our law office of the Public Advocacy Center. She was an elderly woman with degenerative medical problems that caused her to become morbidly obese. Due to her weight, she was effectively homebound and received Social Security disability as a result. When she became disabled, Carol decided to sell her home to a family member instead of falling behind on the mortgage on the condition that she could reside in a small basement apartment that she had made for herself. Because the mortgage could not be authorized for property burdened by a life estate, she agreed with the buyer to have a 40-year lease at a rate of $500 a month, plus a third of the utilities. As the time went on, and you know what's coming, a family member owner became aware that they could get a much higher rent if Carol was not living there. So the owner started to refuse to accept the rent most months. And finally, the owner then brought a non-payment petition against Carol, claiming more than $13,000 in rent arrears and alleged unpaid utility bills. We represented Carol in the 5th District Court, and the attorney for the owner refused to settle. This forced Carol to have to appear in court, stopping twice to rest between the front door of the court building and the tables in the courtroom. Carol slowly and painfully made her way before the judge. Recognizing her mobility issues, the judge allowed her to testify from the table. After a brief recess, the judge dismissed the petition with prejudice, agreeing with our arguments that the owner forfeited the rent by refusing to accept it when rendered the way it had been agreed upon, and found that Carol had not been billed for the utilities and therefore had no responsibility for any past due bills. The judge instructed Carol to pay just moving forward, and if the owner does not provide a bill for the utilities, she does not have to pay anything for the utilities for that month. In a much admonishing tone, by the way, the judge instructed the owner to accept Carol's rent and warned the owner and the owner's counsel not to attempt again to bring such frivolous action before the court. With tears in her eyes, Carol lifted one hand from her walker and placed it on Jack Evans' shoulder. She said, "Thank you so much, Mr. Evans. God was on our side today." Wait, oh, I'm not done. Mr. W is legally blind. He has been suffering from early stages of dementia. He fell behind on his mortgage payments and came to our mortgage foreclosure clinic for assistance. In February 2010, Professor Leif Rubenstein and 2 of our students immediately communicated with his bank and completed documents requesting a mortgage modification. The modification was denied, and a foreclosure proceeding was commenced. We appeared in court on Mr. W's behalf 8 times in settlement conferences over 1 year, and they refused to settle. Each time, either a new or revised document was requested by the bank, and we complied with their interests. A modification was finally obtained in August of this year, almost 1.5 years after we first agreed to assist Mr. W. The foreclosure action will be vacated, and Mr. W, with the assistance of family members, will be able to reside in his home without the worry of being forced out by a foreclosure sale. This is Diana holding her father's hand. She was 3 years old when she and 6 cousins were removed by CPS from home conditions that were described as deplorable. The mother was charged with neglect in family court, and the child spent 2 years living with her father and his fiancée. The neglect petition was finally resolved in August 2010 when the parents agreed that each would have custody for a 3-month period. It was also understood that the father would exercise his custody in another country where he resides. Professor Lou Silverman and the 2 students in the family law clinic received a phone call from the father in January. He was now back in his home country, and the mother was refusing to turn the child over to him for 3 months of primary custody. The father had been referred to us by the law guardian, Diane Somberg, class of '03, a former student in the family law clinic. The 2 students assigned to the case interviewed him by phone, and we agreed to accept the case. The students worked hard to gather the facts, review the records, and prepare the pleadings. At the beginning of May, we applied to the family court for a writ of habeas corpus. On the designated morning, we arrived in court with, and to our great surprise, the mother was in court. After advocacy on our part, the judge ordered an immediate drug test, which she passed, and directed her to be back at 2 o'clock with the child. He also reappointed the law guardian and the mother's assigned counsel and ordered an immediate CPS investigation into the mother's current situation. He asked us to have the father available to testify by phone if necessary, and we called the fiancé to drive to Central Islip immediately. The judge found that the mother had illegally detained the child since January, directed an immediate transfer of the child to the fiancé, who left with her. We were able to obtain a passport for the child, and on June 26th, she was able to celebrate her 4th birthday with her father and family in his home country. You may not know that Touro Law School has been selected by the Suffolk County Legislature and the Suffolk County Executive to house the Suffolk County Senior Citizens Project, representing 200,000 senior citizens of Suffolk County. Marie V. and Charles V. are in their upper 70s, both on Social Security, retired, have never had a legal problem, have never met a lawyer. Mr. and Mrs. V came to our clinic in 2010. Marie was very upset because the son was in the middle of a divorce proceeding and the daughter-in-law was not allowing them to see their 5-year-old grandson, Jay, with whom they had a very close relationship. The grandparents had acted as his babysitters several days a week from the time he was an infant. The Senior Citizens Project lawyers met with the clients in our office to discuss the case, and we appeared in court with Marie and Charles and represented their interest in their relationship with the grandson and their wish to maintain stability. In the second court appearance to the court awarded supervised visitation to the grandparents, and this was an important step because the students argued that the law in New York does not yet recognize the rights of grandparents to have a relationship with their child. The supervised visitation went well. At the next date, the court awarded unsupervised visitation. We were allowed to have Jay go to a cousin's wedding and act as a ring bearer. In the final court appearance on August 17th, the parties agreed that Marie and Charles V. would have visitation with their grandson every week for a minimum of 2 days a week for 4 hours. John Grisham and the Veterans and Service Members Rights Clinic works with many disabled veterans, including many veterans with serious psychological and psychiatric illness, and works on some with multiple issues. Professor Gresham and 2 of our students started working a year ago with J.A., a veteran who had achieved a good period of stability, free from hospitalization. He was a resident in what they call a supported housing program. This provided him with some rent subsidy and a minimum level of case management. He had sunk roots into the community. His tenure there, unfortunately, was threatened by a falling out between the program and the landlord of the complex. Nothing to do with him. Our law students filed a pleading to stall an eviction notice long enough to line up another program that would provide him with a similar subsidy and service in the same complex. And of course, he was enormously relieved and grateful. The clinic is now working to establish service connection to secure VA compensation for JA's schizophrenia, epilepsy, and post-traumatic stress disorder. Professor Gresham and his students believe he has a good chance of securing VA benefits and increasing his income above the bare bones level that he now lives. Professor William Brooks in the Mental Health and Civil Rights Clinic filed a civil rights lawsuit seeking compensation for Michael B., who was involuntarily committed and subject to forcible administration of medication at the Elmhurst Hospital Center. After discovery, the defendants moved for summary judgment. 2 students wrote the brief opposing summary judgment. The motion raised numerous complex issues, including the standards governing the refusal of medication under the United States Constitution and what constitutes objectively reasonable basis to believe that a patient merits the criteria for involuntary hospitalization. Both students then argued the summary motion before the Honorable Carol Ammon in the Eastern District Courthouse in Brooklyn. Unfortunately, the court took so long to decide the motion that Michael B. agreed to take a settlement of $15,000, which we believe he should have waited for a decision. The client was grateful for the money that he needed. And last, Professor Marianne Artuzio, the director of the Elder Law Clinic, was appointed as a court evaluator in a guardianship case by a local hospital. Jerry S., a middle-aged man, had been picked up by the police on a road, dirty, suffering from exposure and unable to make himself understood. He suffered from mental illness and was unable to provide any information about himself except his name. The hospital staff believed he was homeless and suffering from alcohol-induced dementia. Because he had nowhere to go when he was ready for discharge, the hospital sought to have a guardian appointed to make living arrangements for him and obtain financial and other benefits to which he might be entitled. After meeting Jerry S. in the hospital, Professor Artuzio and 2 students concluded that he could not provide any information about himself, and they undertook a fascinating investigation to see if they could uncover any history or relatives. The students contacted public agencies, the police, other departments in the city, and other hospitals and medical facilities in an effort to discover the man's identity and background. The intensive investigation finally yielded a phone number, and when the student called and asked if anyone knew of Jerry S., the response was an excited cry and tears of joy. "You have found him. I have been looking for him for months. I was so afraid he had died." As it turned out, Jerry S. was an outpatient of a state psychiatric center, and he had been living for over 20 years in a foster family home supervised by the State Department of Mental Hygiene. His, quote, foster mother had been frantic. He had left her home early one day and she had never stopped looking for him. She had filed a missing persons report, had posted flyers in her neighborhood, and driven up and down local streets calling for him and calling local hospitals, all to no avail. She feared he had died and was haunted by images of a horrible death, exposed to the elements. We notified the hospital and the court and arranged for a reunion. The students filed a comprehensive report with the court and investigated and recommended a number of safety arrangements that could be implemented. When the court decided to appoint his foster mother as his guardians, the students in the clinic prepared the court documents, enabling her to requalify as his guardian. Okay, Carol and Mr. W and Diana and Marie and Charles V and J.A. and Michael B. and Jerry S. These folks do not know Bernard Lander or Jacob Fuchsberg of blessed memory. They have never sent a note of appreciation to Alan Kadish or to Howard Glickstein or to me. They have not thanked the faculty for teaching law to our students, and they could have never afforded legal assistance, and therefore they ended up in the Touro Legal Clinic. So we asked tonight, what did the builders build? And the answer is quite clear. Yes. The builders built a state-of-the-art law school building, thank you very much, next to a federal courthouse and a state courthouse, with collaboration court programs that are the envy of the National Legal Academy. They have built a tremendous law library with over 450,000 volumes and brought together a faculty of gifted scholars and dedicated teachers. They have built the first public advocacy center in the United States, and they have brought together a group of clinical faculty without peer. And these builders have made it possible through grants and scholarships for students to study the law and practice the law. But here's what they really built. They built a place to save lives. The Talmud in Mishnah Sanhedrin tells us that whoever saves a life, it is considered as if he saved the entire world. Our faculty educates and inspires our students in the first 2 years of law study, and in the 3rd year, our clinical faculty introduce them to the practice of law and to real live people who are hurting and have no place to turn. Each and every day, our faculty and students save individual lives, and it's considered that they saved an entire world. Tikkun olam, the repair of the world. That, my friends, is what the 18 builders built, a place that repairs the world. And for that, we should all be grateful to them and proud to be associated with this special place. Thank you for your attention.